Alex here with part 91 of the My Docket series on child custody and visitation. As with my previous videos, I'd like to take this opportunity to direct my viewers to part 0 if you haven't seen it yet. That's the video that contains the detailed disclaimers and the underlying purpose of the series. Two things that I will glaze over are, number one, I'm not in the middle of this right now. My case is completely and totally over. It's closed. It cannot be reopened, and that's because my ex's parental rights have been terminated. Number two, the nutshell version as to the purpose of the series is to give my viewers one big example of my 8-year-long high-conflict child custody ordeal from beginning to end in chronological order. We left off in part 90 with my ex's attorney's opposition to my motion to modify child custody. I can recall being dismayed and even incredulous at some of the responses that I received from my ex through her attorney. Mainly, it was just shocking to me how little effort she had put into dealing with the issues prior to litigation, and then once litigation ensued, all of a sudden she wanted to put all of this effort, tremendous effort, into the issues that were up. Part of it was not taking our child to school, and the other stuff was not as, it's more in connection to schooling, but not necessarily absences. So I think I'm very curious to see what my reply says. I haven't looked at it in advance, but I imagine it is a pretty lengthy document that goes through each of the points raised by my ex's attorney. So let's go ahead and take a look at what I have filed. Here we have my reply to opposition to motion. Introductory, first paragraph is the standard introductory paragraph identifying myself as the petitioner, indicating to the court that I'm appearing in proper person and that I am replying to my ex's opposition, and I specifically mention the title of our document and the date that it was filed. Memorandum of points and authorities, we're leading off with number 1, and my replies are always a little weird. Typically my format is memorandum of points and authorities. I break down into 3 parts. Part 1 is factual background, part 2 is legal analysis, and part 3 is the conclusion. And with my replies, it's not always going to follow that format because I'm sort of trying to pick out the new issues raised by my ex's attorney. So typically I just kind of create my own headlines or topic lines or whatever you want to call it. And in this case, it's father has attempted to communicate with my ex before filing a motion. And first paragraph, let's see what I state. I attempted a joint decision with my ex, and I cite my motion to modify. I cite exhibits 2 through 7. My ex, rather than show good faith efforts that she's made in replying to me, relies on the claim that my efforts essentially were not good enough. This is a wonderful reply to my ex's claim. My ex is trying to paint me or portray me as a vexatious litigant, somebody who is filing serial papers to just harass her. That none of my filings have any merit. I'm just filing a bunch of things to drive her nuts. And rather than her file an opposition and actually provide exhibits of how she tried to work with me, like show, for example, Alex says I'm not communicating or I'm not working together with him, but here's proof, here's a text, and here's 2 emails of me trying. Rather than do something like that, she's saying he didn't try hard enough. He didn't put enough effort into it. Maybe he should have sent another 10 emails. Maybe he should have, I don't know. But that's me trying to expose a contradiction. And this is one of the things that I point out as very useful. I think the video I mentioned this in is facts versus lies. And in that video, I sort of try to get people to shift away from the idea of trying to sound more convincing, and I try to shift people more towards the idea of trying to expose contradictions. And that is, I think, the more effective way to approach any of these cases, because a lot of the people that end up in court and can't resolve the issue have, I hate to say it, some kind of mental health issue or some kind of severe emotional immaturity issue. Most people will try to work together to reach an accord, or they will litigate in a way that shows there's a genuine issue that they both need the court to respond on. But the ones that can't do that, what they try to rely on is their own subjective personal belief as to what's happening to them, and it's often very disconnected from reality. And so they can sound very convincing because in their own head they feel they're right. And when you try to approach them with saying, hey, I sound more believable, or they don't sound very believable, it'll often confuse or trick the court. And if you take the approach of, okay, they're saying A, B, and C, but if you look at D, E, and F, you can see that what they're saying isn't matching up with what they're doing. That's the better approach here. So I'm basically saying that my ex had an opportunity in her opposition to provide proof that she was trying to work with me. She didn't do this. All she did was say, Alex didn't do enough. Sure, he did these things, but that's not enough. He could have done more. Moving on. Next we have... Oh, second paragraph? No, that's all one solid paragraph. We have intentional sabotage or gross negligence of a child's educational warrant to change of custody. This is obvious. By the way, guys, it doesn't look like I cite Rooney v. Rooney, but that's what I should have done. In Nevada, we have a case called Rooney v. Rooney. You can't use this in other states. But in your state, you probably have something similar with a different headline or caption or whatever you want to call it. In Nevada, the case describes what you have to do to show adequate cause to get a hearing from the court. And in Nevada, you have to show a couple of things. I wish I could remember now off the top of my head, but the gist of it is you have to show that you have made allegations that, if those allegations are true, warrant some kind of change of custody. I think there's more to it than that, though. So if you get a chance, take a look at my video. I think it's called Adequate Cause for Hearing. If it's not, it might just be in the video hearings, and if it's not there, it might be in the video motions. And if you check all three and you still have any questions, definitely send me an email. Those are all three important videos, so even if I'm wrong, you will not be harming yourself by checking those videos. Anyway, this is not the point for me to prove I'm right. This is only the point for me to prove that my allegations, if true, warrant modification. And the reason for that is because where you prove that you are right is at the evidentiary hearing or trial, not in the papers. In the papers, you're just briefing the court, making allegations and assertions. In the papers, what you're trying to do is show the court that these are the things that are going on, and if I can prove it, then I am entitled to the relief that I am requesting. So I'm stating here that my ex, who's alleged to be intentionally sabotaging our son's education or grossly negligent, those actions, if true, warrant a change of custody. And I'm trying to say at this point in time, not that they are true in the sense that I proved it through these papers, but rather that given the opportunity, given a hearing, I will at that point prove it, and I will, having proved it, get a modification of custody. So let's move on. Oh, and I think I broke it down into a change of circumstances and then the best interest, but I didn't really use those labels, and I probably should have. If anyone wants to know what I'm talking about with change of circumstances, please watch the video, Change of Circumstances. A lot of states require you to show this, and if you don't show it, then you can't even get to the point of best interests. So definitely take a look at that video. Our child is struggling due to my ex's misconduct. We have long been unable to cooperate, and while it is ideal for parties to cooperate, it is not the basis that I am attempting to modify custody. Firstly, the modification is a last resort. It would be preferable if she took him to school, she cooperated with school personnel, she turned in homework, etc., etc. This is me once again trying to sort of jar the court out of its annoying approach. The court has this irritating / annoying approach that we should be doing this particular thing, so therefore, since that's what we should be doing, he's not going to give us relief. And I'm trying to basically say, you need to wake up, judge. We're not going to do what you say we should do just because we should do it. We need you to pay attention to what is happening. We need you to pay attention to reality. It's not what idealistically could occur that should govern his decision in the case. It is what is actually occurring that should govern the case. But he has this wrong-headed approach that because we should be able to do A, B, and C, he's not going to intervene. And that's, I think, what led to this case going down the wrong path for so many years. Here we have my ex's allegation that our son was kicked out of school. It's false. Our son could have remained in kindergarten if we had decided so. Ironically, my ex alleges that our son is unfit for Coral Academy of Science. because he is struggling in school. When the reason, if any, that he is struggling in school is because A, she's not taking him to school, B, she's not turning in his homework, 3, she's not supporting discipline needed, and 4, she's intentionally refusing to cooperate with the school. And this is what I call the, I think I call it the self-fulfilling prophecy, but that might fit. Basically, she's reached a conclusion that she wants to be true. I have a video on this called reverse, what is it? The conclusion before the facts, where a person reaches the conclusion before they actually analyze the facts, and then they move backwards from there to try to create the facts necessary to support the conclusion that they want to be true. Anyway, she wants him to struggle in school. She wants him to be kicked out of school. She wants him to fail. And the reason she wants him to do all of those things is because then she is vindicated that what she stated to the judge was correct, and that is that our son is not intellectually capable of handling a charter school. This is an inane notion, but that's what she wants to be true. And so to make that true, she has to engineer it. She has to take certain steps to make that conclusion come true. So the first thing she has to do is not take him to school. Then he's going to go ahead and miss a bunch of lessons, and it's going to set him up for failure. The second thing she has to do to make him fail is to not turn in his homework for 4 weeks. Wow. So that's for a month. The third thing that she has to do is not support the school in its disciplinary process. So when the school tries to discipline him to get him on the right course, she needs to take actions which will undermine that process. And then the fourth thing that she has to do is to refuse to cooperate. So when the school is trying to set him up for success and give her some ideas of what she should do, she needs to then identify those ideas that the school wants her to take and deliberately not do them. By doing these 4 things, she's engineering the conclusion that she wants to be true to come true, which is she's setting them up to fail. Again, guys, some judges don't think that a parent will do this. The only thing that you can do with judges like this is fire them. You have to remove them from the bench and replace them with another one that will. Typically, it's judges that don't understand either abnormal psychology or mental health issues. I'm sorry to say it, but that's the truth. You have to purge those judges from the bench and replace them with the judges that understand that this is a possibility. Moving on. My ex admits that our son turned over mail to her that was sent to him. What? No, she admits that I turned over mail to her that was sent to me. This is the type of conduct that reflects cooperativeness. Anyway, moving on. My ex uses excuses for not taking our son to school, and those excuses lack merit. She's been notified by Mrs. Turner. I think that's the attendance keeper. Mostly, yes, I'm sure that's the attendance keeper, that it's necessary to call the school to notify them of absences. And second, she has emailed, or I have emailed her after the 4th absence, that it was necessary to call. So basically, she's trying to play dumb. She's trying to say she doesn't know that these are the rules. And I'm saying, you do know, because number 1, the attendance keeper has told you, and number 2, I've sent you emails. So this is, again, I'm exposing contradictions. She's saying one thing, and I'm showing proof that that one thing isn't true. Let's see here. My ex's allegations that she fails to appear at our son's before school starts meeting are disingenuous in the extreme. Opposition, page 4. I informed her of the initial meeting date. She reacted with anger, requesting that the date be changed. I then changed the date and gave her the new date, to which she replied, that works. So I don't know what that's about there. She's trying to say that she's angry because she didn't get to the meeting. I guess what I'm trying to say is she got the time wrong. I don't know. Maybe there's an exhibit that I can look. Oh yeah, exhibit 1. So we'll take a look at that. My ex is not entitled to attorney fees. I cite DCR 13.3. She's required to constrain her points and authorities to arguing why my motion should be denied. She cannot remove. Okay, so what she's doing is she's requesting affirmative relief. I guess that's what they call it. I guess she's allowed to do this. I've asked the Supreme Court about it in an appeal, and they had no issue with it at all. So I suppose a litigant can do this, and I think it's a very, very common practice. So I'm going to just move on. There's pluses and minuses to this approach. So there's no reason to get into it, because in our state, the court allows attorneys to do this. They allow them to first oppose a motion and to then request affirmative relief in that motion. And so if the court system here is going to allow it, there's no point in me trying to debate it now in this video. So here we have a citation to subsection 2B, which is the attorney fee sanctions statute. And I know I've cited this before. And guys, I talk about this statute in a video titled Defend Against Attorney Fees. So I'm going to probably skip past this because I've already talked about this at length. By the way, guys, before you are happy with what I state in the video, Defend Against Attorney Fees, Please watch the video attorney fee equalizers because the legislature changed the law after that particular, I'm not going to say after that video, but the law that I used to defend myself is no longer as powerful as it used to be because of what the legislature did. Moving on. Father is not filing a motion to harass my ex. I deeply care about our son's education. The only action taken is to give my ex every opportunity to address these crucial issues, and the court should take note that from the beginning I requested joint physical custody, and not once, even after all the bickering and litigation, did I try to modify custody. I'm only now doing so as a last resort. The court should partially rule on the pleadings. I'm asking the court to, what am I asking the court to do? Hold the issue of modification of custody in abeyance and resolve all the other issues requested in the motion. So I'm basically telling the court that my ex is not objecting to anything else, and so the court should just give me what I want. And sorry to say this, guys, but I don't know if it's that they're lazy or if they're just too busy, but it seems to me that the family division, at least in District 2 and 8, they're just way too busy to do stuff like this, and they typically will just wait until the hearing date to resolve everything because they just don't have any time to give you partial relief to help you out right now. I wish they did. I think it would be more efficient because then at the hearing there would be less issues before the court, and that would save people attorney fees, but they just don't do it in practice. I have never seen a judge do it. It would be really awesome, I think, if they did do this, but they don't. Mediation is futile. So this is the first time that I try to fight mediation. I don't think I've done this before. I'm citing a local rule in Nevada, which is 5314 subsection B3, which holds a few different factors that you can use to block the court from sending you to mediation. And in this particular case, I cite the subsection 3, which is, at this case, is a post-dissolution stage and does involve bitter conflict and frequent court appearances. So I'm basically saying, since this particular factor is true, mediation is not appropriate. Please don't send us to mediation. It's a waste of time. I am able to use this a number of times. I'm not sure if it's going to work this time, but it does start to work pretty much going forward, and the court stops sending us to mediation. It's a waste of our time. It's a waste of our money. It does not work with my ex. It just doesn't work. She doesn't use mediation for what it is intended for. She just uses it as an extension of litigation. Okay. Conclusion. My sole objective is to ensure that our son benefits from a rich education. The rest of this basically reiterates what I've already stated. Declaration in support of the reply, and this is, I don't even know if this is required in a reply. I think it is, since it's alleging facts. Anyway, I'm swearing under oath that the facts alleged are true under penalty of perjury. Rule 5, Certificate of Service. I am indicating to the court that I personally served this document upon my ex's attorney. List of exhibits. Exhibit 1, we have an email. Here we go. I'm telling her that the appointment has been moved to Thursday at 9. School starts on the 20th of Monday. If this doesn't work, let me know. And then she replies that it does work. So no wonder I'm saying it's disingenuous in the extreme. Maybe what I should have said is it's a bald-faced lie. Moving on. Request for submission. Okay, see how this is not a custom form? What probably happens is I showed up at the courthouse, and the clerk mentioned that I didn't have a request for submission, or I noticed that I forgot it, and so I asked, hey, can I get one of your forms? And I just filled it out by hand right then and there at the counter. Request for submission is one of those pieces of paper that you can just kind of whip out in 4 minutes, maybe even less than that. It's pretty standard. It doesn't take any, or doesn't require any citations to law. It just requires you to identify the documents that you are submitting to the court for decision, which I do. Oh, by the way, guys, take a look at the video request for submission if you haven't seen it yet. Not all states require this. Not all jurisdictions in Nevada require this. It's a niche sort of document. Notice of hearing. So this is me setting the hearing. I think 2 videos ago, you'll have seen me having gone over a notice to set. And by the way, guys, if you don't know what that is, watch the video, notice to set. And at that, in that document, I identify a place, date, and time for my ex's attorney and I to set this hearing. So based on this notice of hearing, it appears that we did confer on that date and time, and we did set a hearing date. And that hearing is on January 3rd, 2013 at 1:30 p.m. I do believe you guys will get to see a hearing video, and I'm pretty excited because I think those are the most popular videos in the My Docket series for my viewers. We got Rule 5, Certificate of Service, indicating to my ex's attorney, or indicating to the court that I served this notice on my ex personally, through her attorney. Application for setting. This is the document typically filed by the clerk. So it looks like The clerk is indicating that I appeared pro se, which is representing myself. My ex's attorney appeared for my ex. We estimated the hearing at 2 hours, which is really low, guys. I should not have done that. You know, the attorney probably went along with it because she wanted to sabotage me. That is a bad idea for a motion to modify custody. 2 hours, no way. At minimum, you're looking at 4 hours, and that's like if you have one witness or two witnesses. I should have scheduled this for a full day. And don't fault, this must have been the attorney's proposal. It's disappointing that the clerk didn't object or try to help me out a little bit, but that just goes to show you that they are not friends of unrepresented parties. I think it's because, to give them some credit, I think it's because they think we're just wasting everyone's time, and that anything that we try to do without an attorney is a waste of time and it's pointless, so they really don't try to help out. But it's a red flag to me to see an evidentiary hearing set at 2 hours. I suppose this possibly could have been a hearing on law in motion. Let's take a look. Okay, well, it says hearing on motion to modify, so maybe that's indicative of this being a hearing on law in motion. I guess if that's the case, then 2 hours is fine. In fact, you might not even need 2 hours. You might just need one. The difference between a hearing on law in motion is it's really just an extension of the briefs. You're not really trying to prove everything at the hearing. You're taking all the stuff that you filed in writing, and you're kind of just making your oral arguments to support it. If it's an evidentiary hearing, you definitely need a lot more time than just 2 hours. So it's not clear to me, but it appears to me that maybe this is just a hearing on law in motion, and if that's the case, 2 hours makes sense, and that's fine. Definitely take a look at my video hearings because I explain these little details. Certificate of mailing indicating that the clerk of the court mailed this document to us under Rule 5, which does allow service by mail. I think I have a video on this. Now I can't remember. It might be titled something like service of actually, I know what it's under. It's under notice of change of address. That's the video that really talks about this. Here we have my satisfaction of judgment indicating that my ex has satisfied the judgment. So at this point in time, guys, I have seized the money. Most likely it was seized from her employer. I know I got a little bit from her bank, but I got the rest of it from her employer. And I don't think we've gone over the writs of garnishment or execution yet, but they will eventually come up in the series. They don't get filed right away. They get filed like a month later. It's interesting. And the certificate of service here indicating that I served the satisfaction of judgment upon my ex's attorney. Going into the aftermath, I filed 1, 2, 3, 4 of these documents. They were all free filings, so I incurred $0 in costs. My ex's attorney filed nothing, so she incurred $0 in costs. I didn't have an attorney, so I incurred $0 in attorney fees. My ex's attorney, let's take a look at the quick documents first. So the request for submission, 1 minute. Application for setting, 1 minute. Actually, I could lump in the time that she was on the phone with me. So that's probably going to be more like... let's see, I think 13 minutes is fair, and then we can add the 1 minute from the request for submission and the 1 minute from the satisfaction to bring us to a total of 15 minutes. The notice of hearing, I guess that's just 5 minutes. She probably, mainly just to communicate to my ex that there's a hearing date. Probably not much looking at that document except to set in her schedule the date and time of the hearing. So we're at 20 minutes so far. The reply to opposition, there weren't really any citations to law. I don't really think it had anything in there that my ex's attorney didn't know. Quite frankly, she probably knew that my ex messed up. So I highly doubt that I shocked her with anything that was in the reply. So I think 10 minutes is reasonable, which will take us to 30 minutes at the rate of $250 an hour. That is $125 in attorney fees for my ex. If you have any questions, feel free to post them down in the comments below, and I will see you guys next time.